What are the legal risks of terminating long-term employees? Imagine investing years into a worker only to face a costly legal battle when you decide to end their employment. It might seem straightforward, but there are many legal pitfalls that can trip up employers. Even though most jobs in the United States are at will, meaning employers can let employees go for almost any reason, there are important exceptions. If you ignore these, you could face serious legal consequences. Most employees work at will, which means an employer can end employment without cause. But this does not give free rein to fire anyone for illegal reasons. It is against the law to fire someone based on protected characteristics like race, sex, age, disability, religion, or national origin. Retaliating against an employee for reporting workplace violations or exercising legal rights is also illegal. Long-term employees might have expectations of job security based on company practices or promises. If they believe they have an implied contract or reasonable expectation of continued employment, firing them without cause can lead to claims of breach of contract. A common mistake employers make is not documenting performance issues or misconduct over time. Without written records, it becomes hard to justify a termination if the employee claims discrimination or retaliation. Not following internal policies or procedures outlined in employee handbooks can also make a termination look unfair. For example, firing an employee during or right after they take medical or family leave can seem retaliatory and lead to legal trouble. Ignoring state laws about final paychecks, accrued benefits, or required notices like the Federal Worker Adjustment and Retraining Notification Act can also cause issues. Long-term employees often have stronger claims if they feel their termination was unfair. If they have a history of positive reviews or were promised job security, they might argue an implied contract existed. Employees in protected categories like age are more likely to file discrimination claims. If a long-term employee is part of a group layoff, failing to give proper notice under laws like the Worker Adjustment and Retraining Notification Act can result in penalties. To avoid these risks, always have a clear, legitimate, and non-discriminatory reason for termination supported by documentation. Apply company policies consistently to all employees. Before ending employment, review the employee's file for any promises or patterns that could suggest an implied contract. Consulting with legal or human resources professionals is wise if the situation is unclear. Make sure to comply with all relevant federal, state, and local laws regarding notices, final pay, and benefits. Training managers to document performance issues regularly is a good step. Use standardized forms and keep records in the employee's file. When considering termination, review the case thoroughly to confirm it is lawful and justified. If you have doubts, seek legal advice before proceeding. Communicate the decision professionally and, when possible, give a clear explanation to reduce misunderstandings or claims of unfair treatment. While ending employment of long-term workers is often allowed, skipping proper procedures can lead to legal trouble. Careful documentation, consistent policies, and awareness of legal protections help prevent costly disputes.